Oh, I wanted to ask you. So what happened?
Well, I was, the court allowed me to present for about 10 minutes. They interrupted me once. And I said, well, Justice Binney interrupted me. I said, Justice Binney, if you would like me to go to another part of my submissions, I'd be quite happy. He said, no, that's okay. He said, continue. So let them go on for about 10 minutes. And then they just started peppering me with questions. And you never know what's going to happen. Like they might just start, they can do anything they want. They can just dispense with your submissions and say, we just have questions for you today. Or they might let you get through your submissions and have no questions. I mean, it's like, you don't know what to expect. And so I got a longtime friend of mine who's a top litigator in the US gave me some really great advice on my submissions. And he said, okay, don't take more than 15 minutes. Okay, I sort of knew that already, but he said, summarize your entire case in the first 5 minutes. Wow. So if they stop you after 5 minutes, you can, you've got your you've said your piece. But if they let you go on in the next 10 minutes, elaborate on some ideas from the first 5, and they've let you go on for 15, elaborate further. Okay. But be prepared after 5 minutes that you're not going to have a chance to speak, God. To your submissions directly. And so that's how I prepared, and that was a beautiful strategy for it.
I see. Yeah, because so I wanted to share this with everyone who's watching. So Michael, you have a recording of it. On tape, on a copy on a CD, and I did watch it actually last week. The whole thing. Can you believe that?
Yeah.
The whole thing, and I mean, it's funny because when in the beginning I felt nervous for you. I felt nervous, and then I see the judges filing in, and then when you started speaking, I was like, oh my God, like you were so calm. You're so calm and confident and in control. It was really, really interesting. And so you're right, like you did have to speak. And then when one of the judges started interrupting, I got scared again. And I was like, oh, poor Michael, how's he gonna yeah, because this is something that I remember even like, as a law student, with the first year and the moot and everything, it's actually quite nerve-wracking that you have to be able to think on your feet. So
right. Well, fortunately for me, I don't know why I have that, but I've always had that ability ever since I was a kid. Like if I get interrupted in a situation like that where I'm performing or I'm presenting or something, I remain very calm. I don't know why, but that's just something I bring to the table. So it's not something I've studied or practiced. Yeah, so I appreciate that. I mean, I only had 2 people on one side of the court. It was packed with State Farm executives and lawyers. It was like all against me, staring me down. I didn't want to bring any friends because I didn't want that pressure. And I didn't, yeah.
You didn't want your friends with you?
No, I didn't want the pressure of having to, in case I disappointed, I didn't want the pressure of feeling I can't disappoint my friends. I just wanted to be there essentially on my own. So the 2 friends came with me. Right. One was a former drug dealer and the other is a computer nerd. And they were dressed kind of, in colorful ways. And they were sitting on my side. I think the court must have been looking at them and thinking like, who is this guy? And with these, these nut jobs with him. But yeah, well, so yes, I mean, I was nervous, but once I started speaking, as soon as I heard my own voice, I was fine. And one of the great things about the Supreme Court is it has an excellent sound system. Like they've got that sound system so worked out with the acoustics of the room. And it's kind of like a feedback loop. You can hear your own voice. And so as I started speaking, I was able to assess how I sounded. And I heard my voice gathering, I heard myself gathering confidence as I spoke and as I moved through my submissions. And so I actually became more confident the more I spoke.
This is not because you have a microphone in front of you?
Yeah, you do. Yeah, you're mic'd.
You do have a mic, but yeah.
Yeah.
But the acoustics in the hall was amazing.
The acoustics and the sound. Now that's an advantage that I had not anticipated. But in the moment, I used that advantage to try to improve my performance.
Moments where a judge asks you a question that threw you off and you weren't prepared for? I'm just wondering.
Yes. Well, there were a couple of times that that it was Justice Binney, and I forget the name of the other judge, actually, she's no longer in the court. They asked me questions during the main part of my submission, because there's a 5-minute reply at the end, right? All the sides get a chance to reply at the end. So in my reply, I was asked a question. I didn't know the answer to it. And I already discussed this. I already knew what I was going to do. That if I didn't know the answer to a question, I would just admit it's better. Like you're not going to con the Supreme Court of Canada.
Right.
You know, like you better fess up and tell the truth. If you don't know, you don't know. Right. And I talked to my friend in the States, the big time litigator down there, and he said, yes, you're quite right. If you don't know, as a strategy, it's better to say you don't know. So Justice Binney asked me a question, and I wasn't certain. I said, yeah, I think that is in the record, Justice Binney, the document you're talking about. But then I said, no, Justice Binney, on reflection, I can't say that with certainty. So I'm sorry, I cannot answer the question with certainty. I apologize. And he said, that's fine, Mr. Alexander. Go ahead, carry on with what.
Okay, that's good. That's good, because I think a lot of maybe us, we worry about having to make up some kind of answer or something.
No, sometimes it's just better to say, yeah, I'm not sure. And then maybe explain why you're not sure, if there's a particular reason you're not sure, right? Because there may be an ambiguity that actually the judge is probing, that maybe even the judge is experiencing that ambiguity, and maybe, just wants to expound on that a little bit. As to what the cases are really saying, or how to really define a certain principle or something like that. But I will say, during the main submissions, I did get 2 questions that I did not understand at first. So I just said, I'm sorry, I'm not sure I understood the question, Your Honor. Would you be so kind as to repeat it? And then I got it the second time.
So I guess the mindset is, don't think of it so much don't put so much of an emphasis on the sort of the interrogation part or adversarial part, and think like when the judge is asking you questions, it may truly be because they want to for you to elaborate a little bit more, and they don't understand. So they're not trying to put you down. They're just trying to get at the truth, or get at what happened.
Right. Like you can't assume. Now, there's certainly some judges that are very old school, and they think the only way to test you is to be abusive with you and to yell and to badger. They don't do that at the Supreme Court, maybe because it's on TV and they don't want to look like they're right. They don't want to look bad. But that's not what. But I certainly have been in front of judges like that. And the thing is just to keep your cool, because that just may be. As I say, I don't believe in abusing people, who are presenting, experienced lawyers or not. I don't think that's the way to go about it. But if you do get somebody like that, you just have to think about that person might be like that beforehand. If I have somebody who is an abusive judge, how will I deal with it? And the most important thing is to keep your cool and answer the questions calmly. And something else I would add about that is that, so I adopted an attitude, which was part of my strategy in relation to the court, that this was going to be like defending my thesis at Columbia when I wrote my thesis there, that I was going to go in and talk to a bunch of really smart people who were interested in the truth of the matter. And, I couldn't say beforehand, if I were properly humble, whether I'd gotten to the truth of the matter or not. But we were going to engage in a collective exercise to see where the truth of the matter is. And that ultimately what mattered, particularly in a Supreme Court setting, is that there's a collaborative process and that you end up with the right answer. And I was somehow just a player in a role. In a much larger drama. And so I went there with, I think I've got the right answer, but if it turns out in the end I don't have the right answer, then maybe the result, if it goes against me, maybe that's better for the country. But I will play my role here. And so I thought about it less as they're going to be antagonistic with me, but that we are embarking now on a journey to discover the truth of the matter. And I think I'm leading you to the right destination, but if it turns out that I'm wrong, I myself must bow down before the truth. And so I conceiving of it that way also took a lot of pressure off me, but it also conditioned how I spoke to the court, because I didn't want to speak to the court with any kind of hubris, or arrogance or any attitude whatsoever, superiority, but with an attitude of humility. Here's what I think.
Right.
I'm willing to have you assess what I think. And I actually think that that's not a bad approach to take to any kind of proceeding. But I think it's particularly suited to the Supreme Court. So that's one of the ways I took pressure off myself.
Okay, so you mentioned result, and I think at this point I'd like to ask you. So the result.
Okay. Well, after I finished my my remarks, I turned around, and the Royal Bank people were right behind me, and they were going, "Mike, wait!" All of a sudden, they're talking to me like we're best buddies. "Oh, Mike, way to go! What? Wow, that was terrific!" And I go, "Okay, well, if you think it's good, I guess it must have been good." They decided the case on an accelerated basis, and in a few weeks, we got the decision, and I got a unanimous judgment in my favor.
Yay!
Yay! Yay! Yeah.
How did you feel when that happened? Well, actually, first of all, how did they send you the result by email, like a phone? Like how did that happen?
Fax.
Oh, that's right. We had faxes back then.
We had faxes back then.
So you got a fax.
I got a fax, yeah.
So
And
how did you feel?
and actually, I roll call. That is how I actually received the decision.
Yeah.
But there was actually somebody at the court. They first dispensed the case right at the court. So you send a runner to get the judgment.
Oh.
So yeah.
Okay.
And so I had somebody pick up the judgment actually before I got the fax. And I talked to him over the phone, and he read the judgment to me, and I'd won. And of course I was ecstatic.
Right. But wait, somebody has to tell you to get the runner over there. So how did
Right.
that happen? By phone?
Yeah, I arranged for a runner with a firm that had runners in Ottawa.
No. I mean, like, how did you know oh, today you have to go to the court and get the judgment? Like, how were you notified? How were you notified? That's my question. Like, how did
Oh, that's a good question. I don't know. The runner may have notified me.
Oh, maybe the runner, maybe they,
Like they may have given notice to the firm, and then the firm
Right.
sent the runner, and the runner notified me. I
Okay.
think that's how it went.
Okay,
Yeah.
okay. Well, it's not important.
Yeah.
No, I'm just curious.
Yeah.
Okay.
And yeah, and so that's how I found out. But I had an ongoing dialogue with the court before the case, and I don't know whether you want to explore that now or later.
Okay, can you say it again? What?
Well, I had an ongoing dialogue with the administrative personnel at the Supreme Court prior to my appearance, and that also was a very interesting experience.
But I want to go back to the hearing day, because I'm sure that people are always interested in that.
Yeah.
Did you feel that you were listened to by the judges?
Well, that's a very interesting question for me, because you see, the Supreme Court discourages anybody from representing themselves.
Yeah.
They actively discourage it.
Wow.
They let it be known they don't approve of it. You have the right legally, but they don't like it. They don't really like it. And they particularly don't like lawyers representing themselves.
Is this particular to the Supreme Court, or is it just courts in general? They don't want people.
Oh, I think courts, a lot of judges take that attitude, that they prefer to have lawyers running the show, but it's particularly pronounced at the Supreme Court, I would say.
Oh, but maybe they feel it's because it's not fair to a layperson to represent themselves because of the.
Yeah. I don't know actually what their motives are ultimately. I can't say, because I didn't really explore that. I don't want to speculate, but I did know that they're not keen on that.
They're not keen on
Okay. So I knew that kind of the cards were stacked against me going to the courtroom. First of all, I am trained as a lawyer, even though I'm not practicing. I'm trained as a lawyer and academically, and I'm going in there sort of against their recommendation. So, and also then I'm going in there without my robes, and they don't know why I'm not wearing my robes. So they're thinking I've got a big attitude on, right? Right. So I had to explain right at the beginning why I wasn't wearing my robes.
That's interesting.
Right. So that I wasn't presently a member of the bar, and so I'm not authorized to wear robes in this situation. And so once I said that, then the whole atmosphere in the court changed. And so I sort of had to get over that hurdle with them. And in that first remark, I did in the way that that actually was, in some sense, one of the most important things that I did to create the right relationship with the judges. And something else I did too was that I had noticed in watching Supreme Court appearances on television that some lawyers clearly had not learned anything about the judges and did not address them by name. He kept saying, Your Honor, Your Honor, Your Honor, Your Honor. Other people did know the names of the judges. And I'm like, this is the Supreme Court of Canada. You should know every justice and you should know their background. So I studied all the judges. I studied their bios. I asked friends who knew of them, questions about their background and things like that. And I didn't do that just to sort of gauge how I might argue given the expertise of the court. That was one element in my strategy. But I did it for another reason, which goes to communication strategy. I wanted to be able to look those judges in the eye and convey to them that I knew them. I wanted them to be able to connect with me and see in my eyes that I could speak to them by name and that I knew something about them, right? And so I referred to every justice by name. And I think that was an important element in the court getting comfortable with me, is that I'd done my homework and I was in a position to make a connection with them. Yeah, and then once I got sort of over that initial hurdle, right, those hurdles, I should say, I felt that Justice McLachlin created an amazing atmosphere in the court. She made me feel very welcomed. Wow. And very open, gave me a little bit of extra time at the end of my submissions, both in my main submissions and my reply. Yeah. And so I think that she just created an atmosphere in that courtroom that made you feel like, in the end, the court was really going to listen to you and that they were serious about achieving justice, that they wanted a just result. So that's one aspect of the appearance that was ennobling, that like inspiring, motivating, is the atmosphere that Justice McLachlin created. And if I ever get a chance to meet her, I will thank her for that.
Oh. So I'm coming towards the end of the interview now, and I just wanted to ask you, is there anything you regret doing, or would you think now that you're thinking over, would you do differently?
Yeah, so only one thing, actually, Heather, okay. Only one thing. And that is, I relied on one case that I shouldn't have relied upon. Oh. and I didn't, because it gave me support initially. Like, it was the first case that I discovered in my research that gave me fundamental support for my position. Mm-hmm. And after the hearing, in fact, like the day after the hearing, I realized, well, the way this decision may go, I should have argued that case would have to be overruled. And
oh my goodness.
But the way in which I argued it did not hurt my case. But I'm just saying, from the standpoint of perfecting my presentation, I would have put a different emphasis or a different spin on that. Spin's not the right word, but a different gloss on that case than I did. But ultimately, it didn't hurt me. But you have to be honest with yourself afterwards. I'm pretty flinty about assessing my performances. And so the day after, I was pleased with myself, but I said, you made a mistake there. If you could go back, you would change that, right? And so, yeah. So, that's my only regret about it.
Yeah, so any final important tip or anything that you want to share with other young lawyers or self-reps here?
Yes, there is actually. Don't overestimate what lawyers do. Okay, because, and I'll say this as a little bit of a maverick, that most lawyers don't know how to write and most lawyers don't know how to speak. Okay, because they're way too caught up in their legalese. And the whole point of effective writing and effective speaking is to get outside of your technical terms. You use the technical terms that we absolutely must you know. I mean, and there are certainly, you know, in law, there are technical terms you must use to describe a particular case or a particular ruling or whatever it may be, concept. But most of the time, it's better to write very plain, clear English, like you're writing for the average person who's going to read this. I always want to produce materials, like I'm always thinking the judge in this case is probably overworked, and he or she is going to be looking at my fact at 11 at night before the night before the hearing, and is going to be really tired. And how pleased is the judge going to be when he opens up, you know, looks at the first page of the fact document and realizes, wow, this really reads well. I can whip through this and then I can get to bed early, you know? So that's how I write these things. The other thing is that so if you just focus on being clear and presenting yourself, you know, in the clearest possible way, using the language that is natural to you and most other people, that is going to help you. Okay. And it will create a certain tension between you and probably the other lawyer in the courtroom. The second thing is that you want to get right to the point. You know, like, don't mince words, like get right to the issue, right in the first 5 minutes of what's in front of you. So you say to the judge right away, here's the problem we're grappling with, you know, like just get right to it. Don't go for a lot of introduction. And then, so if you get through that point, then you can elaborate, but get that point right at the beginning. Also, I just want to tell you a brief story. I was in a motion hearing one day. It's like a motion hearing where it sort of goes lawyer after lawyer after lawyer. So you have like, I had like 25, 30 lawyers in the room waiting to get up there. And one lawyer got up there. She was representing a college at the University of Toronto. And she was against a woman who was from China, who spoke very good English. She was a graduate student at the University of Toronto. And she did not want to vacate the residence. And she had particular reasons for wanting to stay longer. And so the lawyer got up there and, you know, she, you know, presented her submissions. And then the student got up there and she stood up straight. She was very well dressed. She spoke impeccable English. She spoke very plainly and clearly. And she was a better speaker than the lawyer. And the emotional impact of her presentation, just because she spoke so well, was just like, I'll never forget it, right? And actually, she ended up winning on the motion. But she was not a trained lawyer. She did not go into, so I'm just saying, like, don't underestimate the power of just being a good speaker. And that's what you, as a self-represented litigant, focus on that as the first part of your preparation.
Oh, that's really interesting. So don't be too discouraged because you're not a lawyer. If you're
No, don't,
right.
Don't be too discouraged.
Wow.
Yeah.
That's really funny because, yeah, I think that a lot of, I want to say us self-reps, we hear the opposite. You know, you can't do it. You can't do it is what we hear all the time. You know, you're going against a Bay Street lawyer, you're going to lose. We hear that all the time as self-reps. Yeah. It's interesting to hear.
Well, there are certainly true. Like, I'm not saying there are some Bay Street lawyers who are just exceptional in everything. And if you come up against that kind of lawyer, I mean, that just may be, it's not your day. You know,
but doesn't justice speak for itself? This is what I always struggle with, because at the end of the day, it's not about whether someone is Bay Street versus a layperson. I thought that our justice system is on delivering justice, not whether someone is self-represented or not.
It should be. It should be. Yeah. And I think judges, and I have seen some judges do that. For instance, in the motion hearing I was talking about, the judge was just terrific. He was obviously a very smart man, but he had a very gentle demeanor and was very respectful of everyone. In fact, I tried to raise issues with him that weren't really within his jurisdiction, and I tried it twice, and he just said, "Mr. Alexander, I'm sorry, you know, it's not within my purview to address that." You know, and he wasn't nasty about it. He just said, you know, "Sorry, I can't accommodate you." And I just appreciated that he was truly impartial in the way he spoke to me. You know, but a judge, I have been before judges. I've seen judges, particularly in small claims court, by the way, because I've done a few things in small claims court for friends. And And judges have to go out of their way there to understand the
Right.
self-represented parties.
Right.
And some judges really do a great job of that, right? And they understand that the self-represented person is trying to make an argument. They almost be making an argument, and they will help to draw out the implications of what the
Okay.
of what the litigant is saying.
Right.
So I think that the best judges, even beyond small claims court, will do that, and I think they should. The courts exist for the people,
Right.
and I think they should approach self-represented litigants with a certain humility. And if they don't, I think that's wrong.
I agree. I 100% agree. If they want to get a copy of your hearing, can they do that?
Right. Yes, I still have copies available. Yes,
Okay.
if they want to.
All
Yeah.
right, so then I'll just leave. So for our viewers who want to get a copy of the hearing, I will have Michael's email address.
Yeah,
in the
sure,
description
sure.
box, so that they can email you directly. And thank you, Michael, so much for coming in today and sharing your insight and your experience with us. And thank you so much to our viewers. If you're new to our channel, don't forget to subscribe and also hit the bell so that you can stay notified of our upcoming videos. And we'll see you at the next time. Bye. Thank you, Michael.
Thanks, Heather. My pleasure.